You're watching The Legal Breakdown. So Glenn, Talking Points Memo obtained a trove of text messages that were sent to Mark Meadows from at least 34 Republicans. Now, I'm going to go through some specific examples in a moment, but first, why is this different from the other few texts that we've already seen between Mark Meadows and other Republicans?
I don't know that it's different in sort of quality. It's different in quantity. 34 Republican members of Congress who seem to be involved in a concerted effort, some might even call it a conspiracy, to deny Joe Biden his rightful election win and keep Donald Trump in office unconstitutionally. So I think what was so shocking was not only the language of some of these, what I would call treasonous text messages, but just the sheer volume and desperation that we see in the language of some of these texts. But, this, I think, just gives Special Counsel Jack Smith all the more ammunition. And it kind of looks like, because Talking Points Memo got a hold of these and they're disclosing them in advance of the January 6th committee issuing its final report, this kind of feels like a preview of some of what we're about to see from the J6 committee.
Now, obviously, the most striking was Representative Ralph Norman of South Carolina, who texted, "Mark, in seeing what's happening so quickly and reading about the Dominion lawsuits attempting to stop any meaningful investigation, we are at a point of no return in saving our republic. Our last hope is invoking martial law," spelled incorrectly. "Please urge President to do so." So what was your reaction to this? And I'm assuming that you don't agree with the invocation of martial law in this scenario.
Yeah, whether spelled correctly or incorrectly, I disagree that martial law was a player. It really is pretty remarkable that a sitting member of Congress advocated in unequivocal terms, tell the president to do this. If the president were to invoke martial law, he would basically, take control of the government away from the civilian leaders of government. He would deploy the military against, let me say it again, against the American people, the people who had just voted Joe Biden as our next president, and they would have basically suspended all of our constitutional rights. They could literally round up anybody they believed wasn't undesirable, and they could have imprisoned people. And things like the great writ, the writ of habeas corpus, is suspended if martial law is declared by the president. And for those who might not know, the writ of habeas corpus is basically if somebody is being detained, imprisoned unlawfully and unconstitutionally by the government, they can file a writ of habeas corpus and have a judge address the issue promptly. Let me add as a footnote, that was done in Michael Cohen's case when Bill Barr's Department of Justice put Michael Cohen back in prison unlawfully, unconstitutionally. He filed the great writ, a writ of habeas corpus, and a federal judge said, "You're right. The Department of Justice, Bill Barr's Bureau of Prisons, unconstitutionally put Michael Cohen back in prison, violating his First Amendment free speech rights." Why? Because he said he was going to write a book critical of the President of the United States. I share that incident, that episode, because that will give you a flavor of some of what the government could do if Donald Trump declared martial law.
In a way, doesn't calling for like the suspension of all of our laws through martial law, isn't that kind of akin to what Trump called for, which is the termination of the Constitution? Isn't all of this in some way disqualifying because it's kind of completely antithetical to what that Constitution and what our laws are supposed to do and what they're supposed to represent?
It absolutely is disqualifying, and people don't have to take it from you or from me. They can take it from the 14th Amendment to the Constitution, which says, if you took an oath of loyalty to the United States and then you launched an insurrection or gave aid and comfort to people who launched an insurrection against the United States, you are disqualified, period. And, there is an open question about how that gets implemented, but there's no doubt about it. It is disqualifying. And I think it's worth looking back at the federal statute for insurrection, because it says anybody who incites an insurrection, anybody who engages in an insurrection, or anybody who assists in an insurrection. And it sure looks like these 34 members of Congress were doing all they could to assist the insurrection, make sure Joe Biden was denied his rightful win and Donald Trump remained in power unlawfully and unconstitutionally. It's no wonder that guys like Scott Perry, who, for example, was sending text messages to Mark Meadows about Italian satellites, taking over the American voting machines and urging that as a basis to keep Donald Trump in office. Is it any wonder that guys like Scott Perry asked for a presidential pardon because they wanted to get away with the crimes they committed?
I'll tell you what, as a Jew, it's nice to get a moment of relief from owning all of the satellites and let the Italians deal with that for a quick moment here. So, these are private texts. Do you think that that the people who sent these texts to Mark Meadows, or the people who conversed with Mark Meadows, that they were just riding the wave of Trump's bullshit and thinking that they could just kind of use the momentum here to change the election results? Or were they actually high on their own supply and actually believed the stuff that they were spewing? Because again, they were private texts. It's not like this was grandstanding for the public, and it's not like this was like them going on Fox News or OAN or Newsmax and saying this stuff out loud. This was just meant to be between them and Mark Meadows.
I guess it's an open question as to whether any of the sort of 34 treasonous members of Congress believed what they were advocating. I find it difficult to believe that they were just that stupid. I think, as you put it, they were riding Donald Trump's BS, and they really didn't care about the legitimacy of the underlying claim that, the election was rigged or stolen or what have you. This was a campaign to keep a Republican president in power by any means necessary. And at the end of the day, it doesn't really matter whether they believed it or not. If you go out and commit crime and you say, well, I had an honest belief that the money that I was stealing from the bank was rightfully mine because the bank was, charging me too much in fees, that's not a defense to your crime. So it's, I think, a little beside the point. I just have a hard time believing they're stupid enough to actually believe Donald Trump's BS.
Yeah, well, I would challenge you to take 5 minutes and listen to what Marjorie Taylor Greene has to say. So that might challenge your opinions as to whether these people are stupid enough. Generally right now, these investigations, or this investigation, as we kind of home in on Trump, is just to see whether he'll be held accountable. So how does the release of these texts lend themselves to the investigation of that guy in particular, of Donald Trump?
Yeah, that's a good question because, there is an intermediary here, right? It's Mark Meadows. Now, Mark Meadows seemed to be acting as sort of a clearinghouse for treasonous texts. It's an open question as to how many of these messages, if any, got delivered to Donald Trump. And if they did, what was Donald Trump's reply? And that's why Mark Meadows is such an important player in this. Think about this, Brian. These are the text messages Mark Meadows decided to give to the J6 committee before he stopped cooperating with them. Can you imagine the ones he held back?
Yeah.
How damaging they must be. Now, look, we know Mark Meadows was referred by Congress for prosecution for contempt of Congress. I have believed all along that one of the reasons the Department of Justice declined to indict Mark Meadows for that single count of contempt of Congress was because Mark Meadows is a much bigger fish in the criminal conspiracy to overthrow our democracy. And so it makes sense to me, and this is the way I would play it if I were prosecuting the case, to hold on to that charge until I was prepared, until the federal prosecutors were prepared to bring the great big overarching conspiracy to commit offenses against or defraud the United States. Because I think Mark Meadows is right in the thick of that criminal conspiracy. And the hope is, I suspect, that the Department of Justice can develop Mark Meadows as a cooperating witness because he had the ear of the president, and he's going to have some of the most directly incriminating evidence to offer prosecutors and ultimately to offer a jury when Donald Trump is sitting as a defendant at counsel table in federal court in Washington, D.C.
So if that's the case, just as an aside, if that's the case where they're holding on to this stuff because Mark Meadows is a bigger player than they had previously figured, do they hold on to these charges and add them on in addition to a conspiracy charge, or does a conspiracy charge just kind of supersede everything and that's what they go with?
You actually used the magic word, supersede. This investigation is frankly unlike any other criminal investigation, I think, in the history of our country. I mean, Watergate doesn't even come close, in my opinion. Ordinarily, when we investigate and prosecute cases, we will indict sort of a series of charges. We'll indict maybe one readily provable charge, and then we'll continue to go into the grand jury, present additional evidence, and build on that original indictment with what you just mentioned, superseding indictments. And we will do that until all defendants and all charges can finally be brought in one final overarching indictment. The reason I say this one is being handled so differently is because we haven't seen any of those preliminary indictments, right? At least not against anybody in the hierarchy or the command structure of the insurrection. Only the foot soldiers, right? The boots of the insurrection, right. The men and women who were incited and told by Donald Trump to attack the Capitol to stop the certification of Joe Biden's win, stop the steal. So I have to believe that the people at the Department of Justice are going about this in, yes, a unique fashion, but in a thoughtful fashion. And that's why we haven't seen these sort of this flow of indictments that will typically come out until you do one final overarching indictment.
Okay, got it. And so it's not like the impeachment trial, for example, where they say, okay, we don't want to take attention away from our one article of impeachment, so we're just gonna forget about the other smaller stuff and just present one major article of impeachment. It's not like that in the legal space. It's just kind of they will, if the charges are warranted, then they'll just keep adding them on, but they're not going to just forget about something in service of one bigger charge.
There's a lot of tactical decisions that go into that precise issue. You want to charge everything that you believe you have sufficient evidence to prove beyond a reasonable doubt to a jury's satisfaction. But now this is going to sound like I'm contradicting myself. Sometimes if I have an organization, a gang, a RICO conspiracy that I'm prosecuting, there may be lots of crimes that are what I would consider lesser crimes. I don't necessarily want to throw them all into the mix, because then what you're doing is you're almost giving the jury too many charges. And I fear sometimes that they will be distracted by some of the lesser stuff, and they'll fail to focus proper attention on the bigger stuff, the main crimes. So, this is an art, not a science. And there's no one size fits all. But sometimes prosecutors will forego charging some crimes that they otherwise can prove because they feel like it would be a distraction from the main crimes they want to bring.
Okay, totally. Okay, so let's finish off with this. There's been reporting that Special Counsel Jack Smith has ramped up the pace of his investigation. He's brought a number of close Trump associates before a grand jury and issued a number of subpoenas as well. And that's all well and good, but this then presents this question, which is, why didn't Merrick Garland do this at any point over the last year when he was in charge of this investigation? Like, why did it take the appointment of a special counsel to be able to see some movement here?
I wish I had an answer to that question. I have been equal parts Merrick Garland supporter and Merrick Garland detractor. But I think when we see for the first time the Department of Justice, courtesy of Special Counsel Jack Smith, subpoenaing, for example, the communications between Georgia's Secretary of State Brad Raffensperger and the Trump team and the Trump loyalists and the Trump sycophants. We've known about that phone call for going on 2 years now, the infamous phone call between Trump and Raffensperger, find me 11,780 votes and corruptly declare me the winner of the election in Georgia. And the moment I saw that for the first time, communications were being subpoenaed, I asked myself the exact same question you just asked. Why in the world did it take almost 2 years? And I hope Merrick Garland had some plan. There was some reason why he was declining to do it. But I have to tell you, at a minimum, it made me sort of raise my eyebrow and say, what's that about?
Yeah. Well, I guess at this point, we could just find solace in the fact that it's being done now, even if it's a little, unacceptable that it wasn't done in the past. So we'll leave it there. For those of you watching, if you want to hear more legal news as it breaks, make sure to follow both of our channels. They're right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
And this is The Legal Breakdown.